Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by Parliament, by the governor, by the President and Parliament in this fashion. Independent of 367, cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature. Under 356, that's Bomai has held that. You have no such powers. And the executive is only dealing with administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. I'll show Malas Bomai.
Yes. But assuming for a moment that we suppose we disregard the 367 amendment.
Even if you do, then you can't exercise it under 356 at all. That's even, Malas, it will be a dead letter. It will be inchoate. Because you can't amend constitutional provisions, Malas, through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough. Therefore, if that part of the notification, which amends 367, is kept aside for a moment, then what is the consequence?
The consequence is that 356 power cannot be exercised in the same fashion.
No.
To achieve the same result.
See, the 356 power is the power of the state legislature and the state executive.
Yes.
Which has now been vested in the President and in Parliament, respectively.
Correct.
You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the Constitution by taking recourse to 356? Fair enough. We got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue, Malas. I'll address your lordships on that.
Right.
At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later, Malas. Because ultimately, what you then do is Parliament is exercising power as a legislature, and Parliament is exercising powers under 356 as well. Correct, Malas? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373.
I think what they believed was they proceeded on a particular hypothesis that consultation with the constituent assembly is necessary.
That's right.
So therefore they said that all right, we are now going to replace the word constituent assembly by the word legislative assembly. Which they sought to achieve by amending the constitution.
No, it's the recommendation of the constituent. It's not just converting it. You can't.
The first step was to amend the constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it, and Malas, you take the decision yourself.
Yes.
This is very problematic, Malas. And see the consequences of this. That means through an executive order, you can change any provision of the constitution because you have majority. But this majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the constitution.
Exactly.
That point you...
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Malas, now one of your esteemed colleagues has said, Malas, that in fact basic structure, those theories are also doubtful. Maybe it is.
When we refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course it's not binding, Malas, but I'm surprised.
On 11th of November 19...
Parliament doesn't discuss what goes on in the court.
No, I'm not discussing anything.
I am not discuss what goes on in Parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom of...
This is a public...
freedom of expression.
No, I know. Malas, I assume he has the freedom of expression to say what he likes. I don't dispute that, Malas. I'm just saying, Malas, of course, absolutely. We're starting a debate on that because of this majoritarian culture again.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the Parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have
You are right.
expressed his views on basic structure.
Not my view. I'm not. My view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court, Malas. In court, I have that constitutional view. Outside, may have a different view. Malas, anyway, that's neither here nor there, Malas. It's just an aside, Malas. But there must be some element of humor and mirth in court as well, Malas. Not everything can't be this serious. We are
Yes,
Malas, Therefore, see the consequences of this. And then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing. And it says, shall read. This is an interpretation clause. Please appreciate, 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. You can only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
So we saw this notification. Yeah. Then what happened thereafter? We got your submission on this.
Well, I just wanted to mention this. Your Lordship at one stage said the Legislative Assembly could be the Constituent Assembly.
No.
Legislative Assembly is a successor to the Constituent.
We were saying what amendment they made. We didn't make a postulation that the Legislative Assembly could be the Constituent.
Your Lordship said that as a consequence, now that there is no Constituent Assembly, why can't the Legislative Assembly?
No.
Anyway, I was a mistake. I'm sorry.
That can never be a...
That's good. Anyway, Malad, let's move on, Malad. Let's move on. Now, Malad, I want to show your Lordship the original 367. Originally, the Sadri Riyasat had to, till 1965, had to be appointed on the recommendation of the Assembly. A name would be sent and they would agree. In 65, a change was made, in terms of which, Malad, the President could directly appoint the government. That change happened in 1965 in the Constitution of Jammu and Kashmir. So like any other state. So slowly, in any case, Malad, there was a slow but sure obliteration of the kind of autonomy that Jammu and Kashmir enjoyed. All laws were applicable, including TADA, POTA, UAPA, all laws are applicable there, except for land laws and personal laws, Malad. Most laws of India are applicable there at this point in time, in any case. So there was actually no need for any of this, except with the objective of sending a political message that we have done away with 370. That's why all this was done. Now, that's my submission.
After 2019 exercise, approximately 1,200 laws are now applicable. All beneficial legislations which are available to other citizens now are available to Jammu and Kashmir also. Prevention of Corruption Act was not applicable. Right to education.
There was. My learned friend is not right.
Several laws.
Anyway,
let's
not go into that. Let's not go into that. Prevention of corruption law was applicable.
Absolutely. You are right, Mr. Dwivedi. That's not a constitutional point. But
political optics, all laws were applicable.
Just to set the record right, the Jammu and Kashmir Prevention of Corruption Act, somewhat 2006, applicable. So because they were named differently. Anyway, let's leave that. Let's not get into this. Then
actually, they say in this notification of 5th of August 2019 that they're adding clause 4 to Article 367.
That's right.
But it appears that clause 4 already existed in Article 367. Right. So it was really an act of substitution, not an addition.
Not added.
That's a small thing, but it's a substitution really.
Correct. But clause D is an addition, where the Constituent Assembly must be read as...
C remains the same, right? C remains the same.
D is different.
Entirely. D is different, you're right.
And Millard's 2 is also different. All provisions of the Constitution amended from time to time shall apply in relation to Jammu and Kashmir. And the exemptions and modifications subject to which they shall apply shall be as follows. All provisions of the Constitution
and are now... Old clause D goes. The references to the permanent residents of the state, that goes.
That goes.
Because that D is now substituted by the Legislative Assembly being treated as a constituent assembly.
That's correct. That's what happened.
Well, there are 2 different strands operating here. One strand arises out of the exercise of the power under 356.
Correct.
Under 356, you have no power to amend the constitution. Right. If you exercise the power under 356 in relation to any other state in India, you can't amend the constitution. 370 is a provision exclusively in operation in relation to Jammu and Kashmir at the relevant time.
Correct.
So the power which they were exercising was the power under clause D of subsection 1 of clause 1 of Article 370.
Correct. Absolutely right. But Unfortunately, Millers, they couldn't do that because clause 1 dealt with instrument of accession, subject related to instrument of accession, and then concurrent list issues.
No, clause D is wider than that.
Wider.
You're referring to clause A. We're referring to clause D.
Yes, I'm reading all clause A also.
D requires the concurrence of that government.
That's correct.
That is the J&K government.
That is government means government council of ministers, Millers. Government is not under the.
But tell us what happens when there's a 356 in operation in the state of J&K?
Well, let's put it this way, Millers. How does 356 in normal circumstances happen? Millers, the governor sends a report. The report is that the provisions of the constitution cannot be carried on in this particular state. The government of India under 356 Millers takes over.
Right.
Right. Now, at that time, the assembly is in suspended animation. That's the normal way that it is done. You keep the assembly in suspended animation, you exercise your powers. Ultimately, the intent is to restore democracy. Therefore, Millers, towards the end of it, when you know that elections should be held and you want restoration of democracy, you dissolve the assembly and then you hold elections.
Oh, well, Mr. Sibal, the question put was slightly different. Now come to 370 clause D. Such other provisions of the Constitution shall apply in relation to the state subject to exceptions and modifications that the President may by an order specify. Now, as far as this is concerned, therefore, the amendment was made to clause 4 to section 367, which is the interpretation clause. Now, the proviso says, provided further that no such order which relates to matters other than those specified in the last proviso, preceding proviso, shall be issued except with the concurrence of the government.
Right.
The concurrence of the government is the explanation
That's
part.
concurrent list subjects.
No, concurrence of the government
And the
is the
both
the legislative
Constitution of India as well as concurrent list.
Let's assume Council of Aid and Advice of the Constitution of Aid and Advice of the Council of Ministers for the time being in office.
Yeah,
Now, when we turn to 356,
yeah.
now 356 applies.
Yes.
356 applies.
Of course.
Now, if we turn to 356, then we have to go into what is the power if 356 provision has been invoked, who will exercise the power of the Council of Ministers under the terms of Article 371.
Right.
So now the issue would be whether the governor could have exercised that power or not.
Millers, but at the moment I have not reached 356, Millers. May I make my submissions when I reach it, Millers?
Okay.
This is, I will delve into another.
No, we are not on the validity of 356.
Exactly.
We are on the question of power.
Millers, I'll be dealing with the power of 356, Millers, when we come to 356. What happens is that I will ultimately, Millers, my trend of thought will
They
be
get disturbed.
because
Okay.
I have.
But we'll just formulate it and leave it at that once upon the proclamation under 356, all the powers of the government of the state are vested in the president.
Administrative powers.
Yes.
Administrative.
Then can the president, in the exercise of the second proviso to clause D of Article
Amend the
371,
Constitution.
no, not amend the constitution,
Yeah.
exercise the power to grant a concurrence.
Millers, concurrence by what? By which subjects? Please appreciate. Either the applicability of the Constitution, right, with modifications and exceptions, or Millers, applicability of list in the concurrent list. That's all. That's all that there is. It can't be more than that.